State legislatures operate under two conflicting mandates. The 14th Amendment of the Constitution generally forbids them from using race to divide voters, while Section 2 of the Voting Rights Act requires them to consider race to ensure minority groups have a fair opportunity to elect their preferred candidates. This is Louisiana's 2022 congressional map, known as HB 1. In a state where over 30% of the population is Black, this map contained only one majority Black district out of 6, District 2, highlighted here. A federal court ruled that this layout likely violated the Voting Rights Act. The judge ordered the state to draw a new map and pointed to these alternative versions, which demonstrated that a second majority Black district could be drawn while respecting the state's geography. The lower court's order required Louisiana to intentionally use demographic data to draw a second minority district. But that act of deliberate race-conscious mapmaking is precisely what triggers a potential violation of the 14th Amendment's Equal Protection Clause. To satisfy the court's mandate, Louisiana passed a new map called SB 8. It included the required second majority minority district, District 6, but it reached that goal by connecting Black populations in Shreveport all the way down to Baton Rouge, creating a jagged 250-mile corridor. The state legislature configured this district to protect its most influential members. By packing specific populations into District 6, they ensured that high-ranking Republicans, like Speaker of the House Mike Johnson, kept their seats in safe majority white districts. A new group of plaintiffs sued, arguing this district was an unconstitutional racial gerrymander. The Supreme Court took the case and struck the map down. Louisiana had followed a federal court order to comply with the Voting Rights Act. But in doing so, they created a map that the nation's highest court ruled was an unconstitutional use of race. Justice Samuel Alito's majority opinion addresses this conflict by setting a new threshold for what constitutes a Voting Rights Act violation. Alito argues Section 2 of the Voting Rights Act cannot force states to redraw their maps unless there is a strong inference that the state engaged in intentional discrimination. This moves away from the previous legal understanding, which focused on the discriminatory effects of maps. Under that standard, if a map diluted minority voting power in practice, it was often enough to trigger a violation, regardless of why the map was drawn. Shifting the focus from a map's statistical outcome to a mapmaker's internal motivation changes the burden of proof for civil rights groups. It is no longer sufficient to show that minority voting power vanished. They must now provide evidence that the state's underlying goal was to make that happen. Under this logic, proving that a demographic group has less opportunity under a specific map is no longer the end of the legal inquiry. To enforce this new standard, the majority updated the Jingles test, a 40-year-old framework used to evaluate these cases. First, when plaintiffs draw an alternative map to prove the state's version is unfair, they are now forbidden from using race as a criterion. If they use demographic data to build their case, the map is considered invalid. Second, that alternative map must achieve all of the state's legitimate political goals, including protecting specific incumbents. If the state wants to keep a certain politician in office, the challenger's map must do the same. Finally, plaintiffs must disentangle race from politics. They have to prove that voting patterns are driven by race itself, and not simply by a shared preference for a political party. In Louisiana, the original challengers failed these requirements. Their alternative maps would have moved Representative Julia Letlow into a majority Democratic district, likely ending her career. Because the map didn't protect her as the state intended, it couldn't prove a violation. Because the challengers failed this new test, the law didn't actually require Louisiana to create a second minority district. The map they drew to stay in compliance became the evidence used to strike them down. Justice Elena Kagan argues in her dissent that the majority is effectively dismantling the Voting Rights Act. Kagan points to the 1982 amendments to the Act, where Congress explicitly wrote the law to focus on discriminatory results rather than intent. By bringing intent back to the center of the case, she argues the court is overriding the will of Congress. She warns requiring plaintiffs to separate race from politics creates a loophole, allowing states to dilute minority voting power under the guise of partisan strategy. Justices Clarence Thomas and Neil Gorsuch go even further in their concurrence. Thomas argues that the Voting Rights Act was only meant to protect the individual's right to register and cast a ballot, and that it has no authority over how a state chooses to draw its district lines. The Supreme Court's ruling in Callais now provides a brand new set of instructions for every state legislature in the country. In much of the United States, race and political party affiliation are statistically linked. In Louisiana, Black voters overwhelmingly support Democratic candidates. This is significant because the Supreme Court has previously ruled that partisan gerrymandering, drawing lines to favor one party over another, is legal in federal court. States can now defend maps that reduce minority representation by claiming their primary goal was to disadvantage the opposing party. Since politics is a legal motivation, it can be used to explain away the racial impact of a map. As long as a state cites partisan advantage or the protection of their incumbents as the reason for their lines, the Voting Rights Act has little power